Welcome to Hull on Estate and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana Popovic-Montag that will provide information and insights into estate planning in Canada from the offices of Hull Estate Mediation in Toronto. Here are Ian and Suzana.
Hi, and welcome to Hull on Estate and Succession Planning. You're listening to episode 134 of our podcast on Tuesday, October 14th, 2008.
Hi, Suzana.
Hi there, Ian. How are you?
Great.
That's good.
So, we were developing some of the, what we seem to be at now is the sophisticated issues. Some of the, which aren't all that complicated, but they're sophisticated issues that are tied into a classic will challenge. And what our clients can expect on either side, defending or propounding or upholding the will. And we promised that we talk about today a development that kind of stems from the corporate issues that we talked about in our last podcast. And that is some of the other claims that can be made that are equally important, that aren't falling directly in the whole closet of a will challenge proceeding, but are often pursued concurrent, or at the same time, literally, as the will challenge proceedings. So let's start with the classic, the one that was developed in Canada throughout and the UK in the mid-1900s, and that is the concept of quantum meruit.
And that, of course, Ian, I think you're referring to the fact that a claim can be made against an estate on behalf of someone who says that during the lifetime of the deceased, I provided him or her with services for which, now that they've passed away, I should be compensated for.
And that came out of a case in Canada, the Degelman case. And what in that case, it's a great story, because what happened there, and the courts saw this story unfold, is that this nice gentleman helped a woman out and performed day-to-day services for that woman, cutting the grass, looking after affairs and so forth. Almost handyman-ish kind of work, but a lot. And the court said, and throughout his lifetime, he appeared to be under the impression that he was going to be looked after, because the comments from this nice widow were, "You'll be looked after. Mm-hmm. Don't worry." He was never paid during it, so he worked away at this. And the court came, and quite frankly, ultimately, he wasn't looked after. And the court looked at this problem and struggled with it. And it's an interesting development, because we're going to go from concept of quantum meruit all the way through the concepts of proprietary estoppel, all of which sort of tie in together. But staying with the quantum meruit claim, the court said, this isn't right. We're not going to let this happen. You can't do this to people. They can't be expected to have work for free. And so the court imposed what they call quantum meruit. Mm-hmm. That is work and paid for work and services provided.
That's right. And, we've looked at the cases, and we know that these are very difficult cases to predict the result of, and that's because there's such a subjective component to the evidence that a judge is going to hear, and to the evidence, of course, that's going to be led, and to what ultimately, I think, in fairness, a judge says, yeah, that is what would be fair in the circumstances.
And in coming through that analysis in the quantum meruit context, the courts, we find, are typically looking at an hourly wage analysis. They say, well, how long did you work? How many hours a day did you work? Taking it outside of the case that we just talked about, taking it into a situation where a daughter and a mother are alive, and the daughter is the dutiful daughter and works hours on end, does health care help, does financial care help, all of those things that we talk about in power of attorney fights and how we get compensated, but more importantly, gets into the same scenario and doesn't get paid. Well, that angle in the context of quantum meruit, the daughter would naturally want to say, listen, I want to make a claim. And they'd come to see us and say, I want to make a claim. There's a big difference here. We talked about our first case, and that was the work of a handyman, a third party, maybe friend, but not a family member, not a close family member. Now, in the second illustration I'm talking about is a daughter and mother. How do the courts react to that scenario as opposed to the handyman scenario?
Well, as you can imagine, I think a judge will be more reluctant to recognize the services rendered by someone who's a family member than someone who's a third party. And the reason for that is simply because of all of our expectations in society that children do take care of parents, or that parents will take care of children in reciprocity. And so in that situation, it really becomes, I would suggest, a question of the evidence. What kind of evidence can you demonstrate or lead to show the judge that, yes, this was dutiful work that would have had to have been provided to mom, that someone, if it wasn't dutiful daughter, would have had to provide for, and mom would have had to pay for. Brings you back to the question of what kind of records do you have? How can you demonstrate that there was X number of hours that ought to be paid on a certain basis? These are not easy claims really to pursue, but I think they are important ones in a lot of circumstances.
And they really are. And I mean, I'll say it once and I'll say it again. People don't remember this, but sometimes is that judges are people too.
That's right.
And they sit there and they see a case like this, and we're talking about the daughter-mother scenario, and they struggle because they say, you know what, that's what kids are supposed to do. Now, naturally, that's the natural, order of life sort of thing. And then they balance it against, like you say, well, if the child hadn't done it, she would have had to have an independent party, third party do it. And they'll go out and they'll test the market. They'll expect counsel at these trials to have put to them details of what's the market rate. What would that be? What is a duty care nurse, or what is a person to cut the lawn scenario? And so it's really, as you say, it's a tough case. When you're doing it, you almost never remember to keep good records because you're doing it for your mom, because you're also doing it, or the handyman scenario, you're doing it because you were promised that it was going to be okay.
That's right.
And that you'd be looked after. And when the day of reckoning comes and the will doesn't look after you, obviously disappointment comes, and you have to scrounge around and collect your evidence at a time that it may be too late.
Another thing that's particularly difficult, I find in these situations, is that they can tend to be very emotional pieces of litigation. And the reason for that is because typically it's another family member that's saying, you shouldn't have done that. It's the brothers saying, you know what, you were living with mom, you were like living off her back anyways, you should have been providing these services. And that's just not always the case. And so when you add that emotional element to the difficulty, of course, in finding the evidence to support these kinds of claims, they really can be difficult.
Absolutely. And so, having said that, as difficult as they are, it's an element of the process. And when someone comes to see us about a will challenge, there's a bit of a checklist that we like to go through, whether it's defending or propounding it. And the first one is, how good is your case in the will challenge? Right. And we go through that, and we've already talked about that in previous contexts and previous podcasts. Then we say, okay, can we supplement your case with a claim like this to add on, to layer on the pressure to the other side, and then, or vice versa. Are we going to be faced with that kind of claim? If you're going to say, in a classic scenario, that the child has been written out of the will, gets nothing, well, it's not always a full stop there. And the quantum meruit claim might be the kind of claim you would consider layering on to help bolster your position, and it's a strategic position on either side. So, I think that's a really it's a good illustration of where these tangential claims get made in the context of the overall will challenge proceeding. There are many other ones worth considering, and there's some creative ones as well. But from our standpoint anyway, that's the starting point. And that's the quantum meruit claim. There's probably 3 or 4 other ones that are worth considering that are appropriate layering on. And that next one that we could consider is, of course, the concept of proprietary estoppel, because it's an extension of quantum meruit. And the proprietary estoppel claims, I think, they're very, very much used in the UK, and I think are an interesting tool that we want to talk about. And I think what we'll do is we'll spend some time in our next podcast talking about the expanded claim, essentially, of the quantum meruit, and that is proprietary estoppel. So we'll look forward to that podcast.
Absolutely. Thanks very much, Ian. Just a reminder to our listeners to feel free to provide us with any feedback you might have on our podcasts at hullandhull@gmail.com.
And please feel free to call in at 206-457-1985. Thanks, Suzana.
Thanks, Ian.
You've been listening to Hull on Estate and Succession Planning with Ian Hull and Suzana Popovic-Montag. The podcast you've been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other Hull On podcasts or to leave any questions or comments, please visit our website at hullestatemediation.com.